Good morning and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, you can join me every Sunday from 8 to 9 a.m. on this station. At the Clark Law Firm, I represent landowners and only landowners. Never have, never will, never think about it representing gas or pipeline companies. I represent landowners, oil and gas right owners for leases, gas lease extensions, modifications, pipeline right-of-way agreements. Again, all across the state. Well pads, damage releases, compressor stations, meter stations, anything related to oil and gas right development in Pennsylvania is my focus. So if you need representation, looking for representation, looking to learn more, 570-307-0702. Again, anywhere in the state of Pennsylvania, or you can reside anywhere as long as the property or gas rights are in Pennsylvania. You can call us 570-307-0702. If you're not looking for representation, but you're looking for information, you're looking to become more educated and informed, which you hopefully are interested in and what you should be interested in, make sure you go check out the websites. Again, just for information purposes, or to learn more about what we do, what I do, what the Clark Law Firm does, go check out pagasleaseattorney.com, pipelineattorney.com. Outstanding landowner information available on the websites. Also, we archived the prior radio shows, so you can listen to this weekend's show. The show will be up Monday morning, and you can go and check it out. You can go to pagasleaseattorney.com, pipelineattorney.com, and we have hours. I think we go back a couple years on the radio show. Been doing the show since 2010, but I think we have a couple years of prior shows available, which we index by topic, so you can go back, listen to the show of your choice, and really get some good information. With that said, I am super excited about today's show. Sometimes it's a grind. Sometimes it gets tired. You work all week, then you got to do the radio show. But generally, I enjoy doing the show very much. I enjoy doing it. But sometimes I'm tired. It's just the reality of it. But I'll tell you, today I'm energized. I'm excited. We got a great topic. I've been looking to address this topic for a while and trying to figure out how I can do it to make it so it's going to be easy to understand. And I think I'm going to be able to do that. And this topic, as I say often, I look for topics that are going to affect everybody. We broadcast in northeastern Pennsylvania, north central Pennsylvania, and southwestern Pennsylvania. So I'm looking for topics that are going to be a broad-based topic, not that's going to just impact one specific little area or a few people. But sometimes, we focus on some of these smaller issues or bigger issues that affect a smaller number of people, but explain how these issues can go much broader and why they can be educational for you, even though that issue, it doesn't involve you or you're not involved with that issue at all. And this is, well, first off, there are many, many people that this issue may affect. More importantly, even if it doesn't affect you, and I guess not more importantly, but importantly, even if it doesn't affect you, pay close attention, because this issue shows you how there can be extremely complicated laws and issues below the surface that you don't know about, and that the company employee is not going to tell you about, and that's not their job. Why should they? So I'm going to get into this, and I'm telling you, stick with me. You're going to find this amazing. And nobody's talking about this. Nobody anywhere is talking about this, but we're going to talk about it. We're going to pull the curtain back again, and we're going to explain why companies are doing what they're doing today. One of the possible reasons. So stay tuned here, and we're going to get into that in a minute. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'm here with you on this station every Sunday from 8 to 9 a.m. Okay, let's start into it. You know what? You hear this thing all the time. Without further ado, well, I'm going to say with a little bit more ado, I want to say one thing before I really jump into this section. I'm telling you, stick with me. I am excited. I'm truly excited about this. And I think, well, geez, why am I so excited about this? Because this is going to be a show. We're going to really educate you. This is going to be a whole new area of thought that nobody's thinking about, especially north central Pennsylvania. But this applies everywhere, but it's really applying in that area, and southwestern Pennsylvania could be a hot area as well because it involves the development of Utica shale. But before I get there, here's my further ado. Please, ladies and gentlemen, landowners, 2 words: stop signing. Stop signing. Then we're going to go a little further without getting assistance and help from your side. Stop signing. Stop signing. Stop signing. Get assistance. Maybe it's good for you to sign. I represent people who sign contracts all the time. But you need to just stop signing contracts without assistance. Get help. Get help. I just had another client. It happens all the time. I mean, literally, probably every week, and sometimes several times a week, but it happens all the time. I do lease reviews. I do consultations for pipelines, whatever the case may be. Landowner provides me the history of documents that they've already signed without any assistance or help from a knowledgeable attorney. And you may think, okay, I'm going to save some money. I don't need an attorney with this. And that's what all of these people probably have thought. Then they realize, uh-oh, I should have got some assistance, because we can't go back and redo contracts, but sometimes we do get opportunities, and we got to seize those opportunities. And because of the slowdown in the gas production, this has created opportunities, as I've been talking about. This has created opportunities. The whole show last week was about opportunities for the landowner in a down market. May seem like contradictory to common sense, but the reality is when companies stop drilling, that can create opportunities for landowners, and it is creating opportunities. So stop signing and recognize, do I or do I not have an opportunity? By simply signing and not getting assistance from a knowledgeable oil and gas attorney, landowners, I'm confident, this is no exaggeration, I have seen individual landowners miss out on millions of dollars. That's not an exaggeration, literally millions of dollars. I've seen landowners routinely miss out on hundreds of thousands of dollars. Landowners who have just simply signed contracts from the beginning, without a doubt, have cost as a group well into the hundreds of millions of dollars. As a group, the impact of royalties that will be paid for the next 50 and 100 years with deductions on hundreds of acres of property and combined tens of thousands of acres of property. With assistance, many of these contracts would have been significantly improved. And I had a client come in who signed a gas lease in 2011 in one of the most gas-rich areas of the state. We know this. And they signed a gas lease in one of the hottest markets that there is, and they left. I know what the market was at the time. They left so much money on the table, and they allowed for deductions for future royalties, and they have a large property. And the combined impact of the difference between what they signed and what they could have received, which wasn't rocket science. You just had to know what to ask for. You needed to know what the market was. You needed to know what other options you had. Well, this resulted in undoubtedly, hundreds of thousands of dollars in losses in future royalties. I'm saying not thousands, hundreds of thousands of dollars in losses for these people. If they would have picked up the phone and made a call to me or somebody else who knew what they were doing, they would have had a different contract. And they would have saved themselves over time hundreds of thousands of dollars. And probably, the legal fees would be extremely small. But they didn't do it for whatever reason. They thought it was a good deal. They didn't think they needed an attorney, whatever the case may be. They cost themselves, and I hate to say it, hundreds of thousands of dollars. and it wouldn't have been complicated to do, and it wouldn't have been very expensive at all. We got to stop that. We have to stop that. If it's me or somebody else, we got to stop signing. Quit being a signer. Stop signing. Get assistance. I do these reviews and consults all the time. We're talking about usually around 2 hours to get a whole plan, to know, like, hey, wait a second, you might be able to do such and such. We've seen these reviews and consults literally result, dozens upon dozens of times in hundreds of thousands of more dollars for the landowner. Now, there's other times we do the reviews and consults and say, hey, look, it looks like this is a pretty good deal. It's within the market price. Here's the risks you run by holding out. Here's the pros, cons on each decision. And then the landowner elects to sign it maybe. So it's about making, for an hour or two investment, you can find out and learn, hey, what are my options? What should I do? Honestly, I know it's me. It's a business thing, but it's crazy not to do that. It really is. It just is crazy. I meet with people. We do these over the phone. People in Pittsburgh area, Greene County, Butler County, Armstrong County, Tioga County, Potter County, guys in Florida, California, Alaska, wherever. We can do this, and you send me your stuff. We look at it. We have a conference call. Your level of education is going to be so much higher than what it was coming in. And I'm not saying this because, oh, God, this guy thinks so much of himself. That's not what I'm saying. I do it all the time. This is what I do every day. If I'm not on vacation, I'm working. And I'm working on oil and gas lease issues, or not just lease, but oil and gas issues for Pennsylvania landowners and oil and gas right holders. It's shooting fish in a barrel of taking advantage of landowners. We have to stop that. Education and information. And I teased that other section. Stay tuned, because I'm telling you, you're going to find this fascinating. I love this topic. But before I get there, I say, you need to go see somebody. You need to see somebody. You need to understand what to ask for. Well, okay, here's one great little piece of evidence. I'm holding in my hand an addendum from a client. And one of the addendum terms, I say, you got to go. These people earlier lost hundreds of thousands of dollars in a great area, didn't know what to ask for. They didn't know. They weren't educated. They weren't informed. They didn't call a knowledgeable attorney, whether me or somebody else, and they trusted it. They were getting the best possible agreement when I know they weren't, and we could have told them, and it would have been so simple, and it would have had a much better contract. But they didn't, and they signed, and what can we do? All we can do is do better in the future. Learn from prior mistakes, do better in the future. But check out this addendum. And this is some shoddy workmanship. But check out this addendum. The last line, this is an addendum that deals with the location, about approving the location of activities on the surface of the property. At the end of the addendum, this is lifting the curtain on how these companies operate. At the end of the addendum is this sentence in brackets, which should have been deleted, but due to shoddy workmanship by the company or the landman, they didn't delete it. And so they left it in here. Pay attention. Here it is, in brackets. If requested by lessor, who is the landowner. So if requested by the landowner, landman may add any of the following. And then it says access roads, pipeline routes, and tank batteries. So here's the deal. You would not be offered this mutual consent on location for such items as access road, pipelines, and tank batteries unless you asked. So that's the company's directive to the landman. Don't give this language unless the landowner asks. If you don't know to ask, you're not getting it. And if your neighbor didn't know to ask and you ask your neighbor, if a message board doesn't know to ask, you're not getting it. You need to know what to ask for. Look, it's right here. If requested by the landowner, the landman may add the following terms. So you better know what to ask for. And that's a big problem. people don't know what to ask for. All right, I'm way against it. I'm telling you, stay tuned. This next section, these next 3 sections are going to be great, detailed. Stay tuned. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You can join me right here every Sunday from 8 to 9 a.m. And if you missed any of today's show, or you want to go back and you want to listen to hours and hours of All Things Marcellus, go to pagasleaseattorney.com, pipelineattorney.com, and you can listen to today's show tomorrow. And you can listen to many, many other hours of shows which are indexed by topic. So if you want to hear a pipeline show, check it out. Gas show, gas lease, check it out. pagasleaseattorney.com, pipelineattorney.com. Okay, here we go. Dad, turn up your hearing aid. Other people, other listeners, turn up the volume. Pay attention. Put your thinking cap on. It's not going to be that hard. But here we go. I want to explain this issue. So, okay, we have, as I've talked about extensively, have seen that due to the gas prices, natural gas prices being so low, it has impacted companies' ability to drill wells, produce gas. Things have slowed down and have contracted. As a result of that, leases that companies planned on developing, now the company is not using the resource to develop leases. Many of these leases are now expiring or on the verge of expiring. And that verge of expiring may be another year or 2 out into the future, sometimes even 3 years out, where the company knows that they're not going to be able to do what is necessary to maintain this lease so it does not expire. In other words, your lease may expire in the year 2016, 17, or 18, and the company knows that they're just not going to be able to drill or conduct operations that would be sufficient enough to continue this lease. So if you're a company and you have a lease expiring in the next year, 2 or 3, and you know that you're not going to be able to drill and hold on to that lease, what are you going to do? You have to make some decisions. Do you go ahead and allow the lease to expire and go look to negotiate a new lease in the future? Or do you try to develop it? And we're going to say we can't develop it because we don't have the resources as a company. Or do you send a landman out and ask the landowners to sign an extension of the gas lease? And one of the tools or one of the persuasive arguments that you can present as a landman is, hey, landowner, we don't have any money, so we can't pay you anything or next to nothing, but we want you to extend this lease. The first question you need to ask is, well, why do I want to extend my lease now with a company that has no money? But this isn't specific advice for any specific person, and that's a different conversation. I'm not going to go too deep on it right now. But again, setting the stage, companies come out, they know they're not going to drill the well, they know they can't hold on to this lease, so they want to extend it. And they're going to use their best, most persuasive arguments to you as a landowner why you should extend an expiring lease. If you are offered an extension, call me. Call somebody. You can call me 570-307-0702. 570-307-0702. If you are not speaking with somebody, whether it's me or somebody else who knows what they're doing, if you're not speaking with somebody and you have any contract offer, but we're going to talk about lease extensions and modifications, I promise you, you are doing yourself an incredible disservice. Not only yourself, but your children, your grandchildren, the value of your property. At least have a review and consult to make sure that you understand the issues, because you need somebody to explain these issues from your side, the landowner's side. You need it. We're missing opportunities. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You can join me right here every Sunday from 8 to 9 a.m. So, okay, now, we got companies looking to extend leases because they know they can't develop them. This can be a tremendous tremendous opportunity for the landowner. And there are hundreds and hundreds of landowners that are missing this opportunity. This isn't something that happened years ago. This is something that's literally occurring every day today. This is occurring. So, company comes to you, they want to extend your lease. Well, all right, sometimes this can seem pretty simple. Hey, we thought gas prices were going to be higher, we would drill more, and now we're not able to develop your lease. We want to extend it. Again, a smart person is going to contact an attorney, get a review and consultation at least, and understand what their options are. But there's a secondary part to this that gets, again, this shows you how confusing, convoluted, and complicated this can be beneath the surface, beneath what is discussed at your kitchen table with the company employee. So it's real simple when you have a lease and there's been no development and it's about to expire and the company wants to extend it. That's pretty simple. We understand why. But there's a secondary aspect to a lot of these extension requests which is extremely complicated. And here's what that means. In various places of Pennsylvania, North Central Pennsylvania is a primary example, but this occurs elsewhere as well. But right now in the Tioga County area, but this isn't just there, this happens elsewhere, there are leases that have what are called depth severance clauses. And these are a lot of them in the northeastern part of the state and actually a lot in the southwestern part of the state, that you have a depth severance clause. Meaning that, and they can be written a lot of different ways, that your lease only allows the company to drill from the surface of the earth down to a certain depth or level. Sometimes the lease even specifically says that it's a Marcellus shale lease, for example, that you can't go any deeper. You don't see that a lot, but some of them do. Some even have a specific depth as far as footage go. You can't drill lower than 7,000 feet, whatever the case may be. A lot of different ways to write these. But one real common term that is being manipulated or being extended, and landowners don't even understand that it is in most cases, or why, or potentially why. But a secondary part to this is, it's real simple for a landowner, again, to understand, hey, my lease expires next month and the company hasn't done anything at all. So, yeah, that's why they're asking for a new lease or an extension. But sometimes you may have a lease that you may have, if you have 100 acres, maybe you have 20 acres that are in a unit. And you say, well, okay, well, the company has done something. Well, many leases that are expiring or actually are eligible to be expired already or will expire in the next few years or year, many leases, especially in North Central Pennsylvania today, but this applies everywhere, have a depth severance clause or language. And it's not called depth severance, so they're hard to identify. But what they say in many of these leases, it's a pew provision that involves a depth severance clause. Now, what the heck is he talking about? Some people know. Let me explain real quick. Here's what it says. This type of language it's applying now that people don't even know they have says something to the effect of, at the end of the 5-year lease that I've signed, it might be 10, it might be 7, it might be whatever, but at the end of the initial primary term of my lease, and we're going to pretend it's a 5-year lease, at the end of 5 years, company, you only are allowed to maintain or keep under lease from the surface of the earth to the deepest depth that you've drilled, or the deepest formation that you have drilled into. And in many cases today, you have leases that are eligible to expire already, or in the very near future, or sometimes even years into the future, that have language that say, at the end of that initial term, and we're going to pretend it's 5 years, that at the end of the 5-year term, we're going to look at company, how deep have you drilled? And if you've only drilled to the Marcellus formation, which has occurred in many, many cases, hundreds of cases, then everything below that formation gets released or returned back to you as the landowner. But, landowner, you have to write the company and say, I want to have the deeper formations released. I discussed this a lot last week. We need to write letters to get property returned back to the landowner, to get it released. We need to be active and write those letters. So, okay, let me reset again quickly. We have a lease that says that at the end of 5 years, and we're going to pretend it's a 5-year lease. I don't want you to think, well, I don't have a 5 years. It could be 6. It could be a 10-year lease, whatever. But at the end of the primary term of 5 years in our example, company can only hold on to and keep under lease all of the property from the surface of the earth down to the Marcellus shale formation, because that's all the deeper the company is drilled. So back to my example. Here you are, you're a 100-acre landowner, and you already have 20 acres in a unit. But then the company comes and wants to extend your gas lease. They want to extend it. And you say, well, wait a second, I already have property in a unit. Why would they want to extend it? Why are they extending it? Well, the reason why they're extending it is that they want to continue to be able to hold on to or drill deeper into the Utica shale. They want to be able to drill deeper. So they may come to you and say, okay, yeah, we want to extend your lease. And the reason why, and they're probably not going to tell you this, the reason why is because we've only drilled to the Marcellus shale formation as of today. And your lease is expiring or will expire, or actually you're already eligible to have deeper formations released. You just don't know it yet. And we as a company, we don't want to give up that deeper formation, because in many areas of the state now today, North Central, pay attention, Southwestern part of the state, pay attention, there's a lot of excitement about the Utica shale formation. And if the company holds a lease that doesn't allow them to go to the Utica shale, well, they're going to go to the landowner and they're going to say, hey, will you extend your lease, because as of now or in the real near future, it's going to sever Utica so we can't get at it. So will you extend your lease? They don't tell you that. They say, hey, we want to extend your lease, whatever they're going to say. But the reality is they're looking to extend in many of these cases so they can continue to have the right to access the Utica formation. And you as a landowner need to understand, do you already have the ability to cut off Utica from the gas company and negotiate a new lease for Utica formation? Or will you have the ability to cut off the Utica formation within the next year, 2, or whatever? You got to identify this. We have to identify this. Why? Number one, it could be a potential new lease. It could be potential leverage for negotiation of a lease extension. It could be the realization of additional rights that you have that you didn't know that you have. And now you may decide, okay, I want to wait, or I want to move forward, whatever. It depends on your circumstance. But one thing you sure as heck don't want to do is sign the extension without getting some assistance. You don't want to do it. I'm way up against it here. But when I get back, I'm telling you, it gets way better. When I get back, I'm going to explain another reason. The company wants to get to Utica. Why do they want to get it? Maybe big money, big gas there. And maybe they've already lost the rights. They want you to assign an extension. Why? So they can access the Utica. But I'll tell you what, there's a really important other reason why a company wants to get your Utica rights under contract. And I believe that they're terrified about losing large gaps and large acreage of the Utica formation because of a very obscure law, very important on the books, not valid, but obscure law that virtually no landowners know about, and companies sure as heck ain't telling you about. I'm going to tell you about it. That's right. I'm going to tell you all about it right after this break. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'm limited on time, and this is a heck of an important subject, so I'm going to jump right into it. All right. So we know that Down market, companies contract, stop or reduce drilling. Results in leases expiring. Companies don't want that, so they want to extend existing leases, especially company-friendly leases. If you got a great lease, the company will let it expire and come back and try to get a better lease for the company. But if you have a bad lease, the company doesn't want it to expire. So they come back and offer an extension. However, this is an example of some real detailed below the surface issues that most people, most attorneys have no idea about, and certainly the vast majority of landowners, and quite frankly, probably landmen as well. But here's what it comes down to. The other thing that's happening is, even where drilling has occurred, if you have 100 acres, in my example, and you're even part of a unit, the company may still be coming back to you and saying, hey, we want to extend your lease. And you should scratch your head and say, well, geez, I don't understand why. I'm in a unit. You might even be getting royalties. Well, why do they want to extend? Well, another reason is that many leases out there have a pew provision that also has a depth severance clause, which says that at the end of that primary term, which often is 5 years but doesn't have to be. So at the end of your 5-year lease, the company, however deep they drilled, they may be precluded from going any deeper. There's language in a lot of leases. Now, we got to look at your lease to see if you have this. But we know, and there is, and we deal with it all the time, many leases that are expiring now, especially in north central Pennsylvania, but can be all over the place, that says that, well, if we've only drilled to Marcellus or a certain formation, that we can't go deeper under this lease. But if we extend this lease, that gives us more time. So we extend it 2 or 3 years. That gives us 2 or 3 more years to drill a deeper well so we can continue to hold on to this property. Again, common sense tells us, hey, yeah, okay, they don't want to lose Utica formation. A lot of money there. But common sense should tell you, anytime you're given a document to sign, it may be an opportunity. So I'm going to read, this is an outstanding article. It's called Forced Pooling Policies Remain Unclear in Pennsylvania Shale Plays. This is really fascinating, and this is by Laura Legere. I'm not sure if I'm saying that right, but it's Legere from the Pittsburgh Post-Gazette. Outstanding article. I follow Laura on Twitter, outstanding reporter. So this is, again, fascinating. We talk about why does the company not want to lose the Utica formation? One, because they may have a good lease that's to their benefit, and they don't want to lose that lease because they can make more money from it. Another reason is that there's this law called the Oil and Gas Conservation Law. Oil and Gas Conservation Law. You don't hear about that very much. It's an old law, very, very valid. Like, don't think because it's older, it doesn't apply. It applies completely. And within the last couple years, there was this test case to see how this oil and gas conservation law was going to apply. So the case ended where the company was called Hillcorp Energy Company, ended up withdrawing. But let me give you some of the history, and again, we're going to track this article. Hillcorp Energy wanted to use the forced pooling provisions. Forced pooling, meaning being forced into a production pool or unit, even though you may not have signed an agreement. Hillcorp Energy wanted to use the forced pooling provisions of the Oil and Gas Conservation Law to drill and hydraulically fracture Utica shale beneath the northwestern Pennsylvania properties. This just happened to be there. Could be in all kinds of different places. But they wanted to use the Oil and Gas Conservation Law and use force pooling for development of the Utica shale layer, where some of the rights to the Utica had not been released to the gas company. So what it is Hillcorp says, okay, well, we have all these gas rights up in it happens to be northwestern Pennsylvania. We want to develop the Utica shale, but not everybody has signed leases. So they want to force you or force the property owner into a pool, into a unit, even if you didn't sign a lease. But critical here, What's the vehicle? How can they do that? That's the oil and gas conservation law. Well, how come I'm just hearing about this? I mean, this isn't something that landowners are talking about. Well, here's the deal. The oil and gas conservation law only applies to wells drilled through the Onondaga Horizon. The Onondaga Horizon is a geologic layer. It's sandwiched between or located between the Marcellus Shale Formation and the Utica Shale Formation. So, the oil and gas conservation law applies to wells below Onondaga, or the oil and gas conservation law applies to Utica Shale wells. However, the oil and gas conservation law does not apply to Marcellus Shale wells. So the forced pooling, the forcing landowners' property into a pooled unit, that potential does not exist under the current law for the Marcellus Shale Formation. However, the hardly ever talked about oil and gas conservation law, which does have provisions that can force a landowner into a pooled unit, even if they didn't sign, that applies to the Utica Shale Formation. But nobody knows how this thing is going to play out because it's an older law that wasn't drafted at the time of horizontal drilling. So, there's a lot of uncertainty there. But if landowners don't sign Utica Shale leases, or if landowners have leases and they only allow development to the Marcellus Shale, and deeper formations like Utica are released or no longer under oil and gas lease, and you as a landowner, if you did not sign a new lease, or if you didn't extend or modify your existing lease to allow access to the Utica Shale Formation, the company has some options. One is just don't develop it. But they'll tell you, hey, in a lot of these areas, Utica Shale, that's our formation. That's where the money is. That's where the gas is. So they want to develop it. Maybe not today in these gas prices, but they want to have the rights to develop the Utica Shale Formation. So if your gas lease had a depth severance pew clause and you can release or get back your Utica Shale rights, which many do, then that's something you want to do, because now the company then has some options. They can let it go, which most cases are probably not going to want to, or at least not over the long period. They may wait a while until the market recovers, or they come back, company says, okay, if we lease you so we have Utica rights, or we extend or modify an existing lease to make sure we as a company continue to hold the Utica rights. If we do that, we don't need to worry about the oil and gas conservation law. But if we don't lease you, or if a bunch of these Utica Shale rights are returned to the landowner, creating gaps in the acreage that the company holds, meaning if there's 10,000 Utica Shale acres in a given county, we'll pretend, and say that 5,000 are not leased, well, that can be a problem. Well, then the company's going to look to negotiate and enter into a lease with you if that's an area they want to develop. If you don't agree to a lease, the company can then turn to the oil and gas conservation law. However, there's a lot of uncertainty, and I'm going to explain some of the things about the oil and gas conservation law. My point here is, though, is that companies do not want to get involved in the oil and gas conservation law, and they can avoid that by entering into a gas lease with the landowner. So the landowner may have this hidden leverage that they do not, or they are not aware of, and that they're not appreciating. And it can get really complicated, but some of that leverage may be really powerful today because maybe a company wants to drill a Utica well under your property and they have all the rights with everybody, but they don't have your rights. Well, you may have a lot of leverage there. Again, not specific advice for anybody. We'd have to talk about it. We'd have to review it, talk about your situation. But we're always looking for leverage. Why is a company doing, or why are they asking what they're asking? What can you do? What are the pros and cons of whatever decision you're going to make? So, okay, let's talk about the oil and gas conservation law. Under this law, a company must take many steps, several steps, if it wants to extract gas from the properties that have been leased to another company or not leased at all. Now, again, I want to make sure, and I encourage you, check this article out. Forced pooling policies remain unclear in Pennsylvania's shale plays, and that's by Laura Legere, Legere, from the Pittsburgh Post-Gazette, and this article is from January 6, 2015. Really encourage you. Go check this out. Fascinating stuff. So the first step, let me back up. Under the conservation law, a company must take several steps if it wants to extract gas from properties that have been leased to another operator or not leased at all. Again, we're talking about Utica Shale for our purposes. The first step, the one that Hillcorp took in their case, was to apply to the DEP for what's called a well spacing order that defines the pool of gas and the fewest number of wells needed to drain that area efficiently. This is a geological issue. So the first step, so if you didn't lease, you could ultimately be placed in a pooled unit, but the first thing the company has to do is go through this process of seeking a well spacing order. They don't want to do that. The second part, only after spacing units are set. So only after they set the spacing units, then a company or mineral owner can apply to within the unit for what's called an integration order. This is a separate step. It involves a separate hearing that allows, the integration order allows for the company to incorporate non-signed or unwilling landowners into the unit. Remember, we're talking about Utica Shale or deeper, and setting the terms for compensating them. Now that's going to get interesting. What does that mean? Well, a lot of uncertainty there. Maybe that this integration order would be for a much higher bonus than what the company, a per acre bonus than what the company's offering. Maybe the integration order would require royalties at 18%. Who knows? We don't know. Maybe it would say no deductions. We don't know. But we know this. The companies don't want to tangle with this. They don't want to tangle with it. So they want to get you under lease. They don't want to tangle with this language for many, many reasons. So the article goes on and said Hillcorp had not reached the controversial stage of this integration order when it withdrew its application, but the company made no secret that it was heading in the direction of the dread of forced pooling that drove much of the backlash, the public backlash against this proposal. Not popular. So we have very unpopular if a company wants to use the oil and gas conservation law. Not a popular move for a company. Well, they got enough problems. They want to do that. Also, they have no idea how this is going to turn out. So if they're offering you, landowner, $2,500 to extend your lease, and your lease is 12.5%, if I had my choice, I'd rather go as a landowner under the oil and gas conservation law. However, please, 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 this isn't specific advice. This is very complicated stuff. So I don't want you to think, okay, I'm going to do nothing and we'll rely on this law. Because in this case, here's a great example. What the company did, what Hillcorp did in this case, it withdrew that integration. The company said when it withdrew that integration is a legally prescribed remedy for precisely this scenario. But Hillcorp pulled its application so that it could end this, what it called a protracted process. Again, companies don't want to do that. And move forward with drilling on 99% of that target area that it had under lease, that it already had under lease. So the company said, we leased it. We don't need to do this. Companies want to lease your Utica rights and avoid having to use the oil and gas conservation law. Why haven't you heard of it? Because companies don't want to use it. They want to lease you. So you may have Utica rights that are eligible to be returned to you immediately, that are already eligible to be returned, or are eligible to be returned in the near future, and you may have substantial leverage that you're not aware of, that you have to be aware of. But again, this isn't specific advice. Do not rely on the radio show. Get individual advice. This is for general information to understand that these things are out there. Once again, I'm way over my time. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'm here with you every Sunday from 8 to 9 a.m., and I'm going to be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Again, I'm short on time. It's going to be a short segment, so jumping into it. Okay, there may be hidden leverage that you're entirely unaware of if you're a landowner and you're asked to extend an oil and gas lease. Also, you may have acreage now. If you have a PU clause, which I've talked about in other shows, go pagasleaseattorney.com, check it out. Check out the website segments talking about PU clause. If you have that language, you may immediately have acreage that's eligible to be released and returned to you. You have to write a letter. We need to start writing those letters. I just did too. I have a new feature we're doing called Marcellus Talk with Attorney Doug Clark, where I'm trying to do at least every month, where I send out a hot subject and I write an article about it. If you're interested, I recently wrote on these topics. If you're interested, contact the office either by telephone. You can sign up. We send it out by email, or you can email at pagasleaseattorney.com, or you can go on and sign up for it. Really valuable. Really, it's just information. You can check it out. Some you may like, some you may not. You can unsubscribe at any time. It's not something we're going to keep sending you advertisements. But the point is you can learn. There's other educational resources available, completely free and certainly without any obligation. Okay. So what we have then is we have this oil and gas conservation law. Hill Corp was using this, was going through the process, and then they pulled out and said, you know what, we're going to stop and drill what we have under lease. We're not going to try to force pull this Utica formation. So that then we didn't get an answer. We don't have an answer. And as this article points out, that the spacing and integration order provisions of this conservation law have been used only rarely in the last 50 years. And no one who works in DEP, oil and gas division, had ever handled such an application. This means that the crucial issues are unsettled. Nobody in the company side likes an unsettled issue. Get people leased, don't have to worry about it. Such as whether a unit, so the issues are unsettled, such as whether a unit should be defined by the maximum area that can be efficiently and not economically drained by one well, as the law currently states, or by one well pad, where a shell operator can start two or more or many wells that travel down through the shell in different directions from one pad. So again, to summarize, it gets really complicated, but there can be hidden leverage because the gas company does not want to use the gas conservation law, so they really want to lease you. In certain windows of opportunity, which you have to address on an individual specific situation, you may have even more leverage because your property may be blocking development. But again, it's not specific advice. We got to look at your situation. But the point here, the overall point, the big takeaway is there are opportunities and there's leverage that can explain why a company might be doing something that you can't figure out, because there's complicated underlying reasons that you're just not aware of. And in fact, many, and certainly most regular general attorneys are not going to be aware of. So we always come back to, if you have any agreement that you're asked to sign, get assistance. Get assistance. Whether it's a review and consultation, usually takes about 2 hours. Do them all the time. Sorry, commercial. Call me 570-307-0702 or call someone else. Call someone else, but call someone. Call someone. There are a lot of hidden items or hidden underlying reasons that if you are aware of, you might do things differently. I stress, as I always stress, and as always, every show, any show is never specific advice for any specific person. The specific advice to you as a listener is get assistance. Get assistance from somebody that's going to help you, not the company landman, because ask the landman where the checks come from. They're independent contractors, or their company is employed by the gas or pipeline company, not you, the landowner. Not their fault. That's their job. Your job is to be smart, intelligent, informed, and educated. There's free resources out there, but don't sign a contract without representation, because people are losing, like I started earlier, literally tens of thousands on an individual level, hundreds of thousands on an individual level, and even millions of dollars on an individual level. Undoubtedly, hundreds of thousands of dollars, or hundreds of millions, not thousands, hundreds of millions of dollars have been lost or going to be lost by Pennsylvania landowners because they signed bad agreements and did not get assistance. Assistance to just make sure that you're getting the best possible contract. Shaving a percentage point of royalty, getting 2.5, shaving, no deductions, are just simple examples of ways that you can make as a landowner, depending on the size of the property, depending upon the location, tens of thousands, hundreds of thousands, or even millions of dollars. Even millions of dollars. We can't keep making these mistakes. And we got to look at our leases. Guys, we got to look at our leases and see, are you eligible to have acreage released because of your Pew clause with the depth severance? We got to look at that. You're making a mistake by not looking at it. And if you have acres that are eligible to be released, write the company. I've written these blogs. Again, it's coming out too in these Marcellus talks when we send out this information to people. It's free. It's a free, I think it's an incredible resource. I write it, so I'm a little biased on that. But we want to make sure that you're getting this information. Go to pagasleaseattorney.com. Go to pipelineattorney.com. Read the blogs. Sign up. All Things Marcellus Talk with me, Attorney Doug Clark. Learn more about these issues and many others. Finally, I want to let everyone know that we're doing a free seminar, which is going to be only open to Pennsylvania landowners, oil and gas right owners who do not work for an oil and gas company, pipeline company, any energy company, any landman, land service company. Sorry, guys, girls, not invited. This is for Pennsylvania landowners and landowners only. It is going to be in Wellsboro, Pennsylvania, Wellsboro, on Wednesday, June 15th from 6 to 8 p.m. You must pre-register if you want to attend. We're not going to bother you, but we're going to check who's attending. We are going to require that you must be a Pennsylvania landowner and not work for an oil and gas company, because we want to get that kind of information to you. So you can contact the office to pre-register. You have to, because we're not going to let you in, unfortunately, unless you pre-register. 570-307-0702, 570-307-0702, or sign up through the website. Send us an email at pagasleaseattorney.com. Go to the website. But again, sorry, but we want to be clear. We want to have this for landowners only. And you hear this often, but truly, space is limited. So you must pre-register. Wednesday, June 15th, free from 6 to 8 p.m. at the Dean Center in Wellsboro. Learn more, 570-307-0702. I'm up against it. But remember, check out pagasleaseattorney.com. We'll have this show up tomorrow. Join us next Sunday from 8 to 9 on these stations. And most importantly, have a wonderful week, everyone.